Well, hello everyone, and welcome back to One Civil Law. Hope you're having a great day. And we are simply waiting for the court to get back in session at this point. So we're just poking around at the moment, just waiting for the court to get back in session. So things are not looking great against Mr. Daybell. As we learned from today's session, more evidence against him. The darkness of Daybell continues to become more and more manifest. The evidence against... I have to hand it to the state. I mean, they obviously have a lot of evidence to work from. But I think the state has done a better job in this particular case than probably any case in recent memory, in just in sort of like the presentation and the flow of the story. They may have been the best when it comes to just the flow of the story, in the order of the witnesses, in what they're getting from each witness. They get what they need. They get in. They get out. The witness doesn't overstay their welcome, thank God. We go on to the next witness who adds the next piece of the story, and so forth and so on. So, in terms of the sort of ideal that you want, at least to my mind, as a trial lawyer, what you want is that ideal, is to have your witnesses in an order to tell a story arc. And again, that's not always possible because in the real world, they aren't characters that you can just write. The witnesses have information as they have information, and you have to call them in some order. And sometimes you have to make compromises about, what you can do, because sometimes you have to tell parts of the story out of order because, you can only really call the witness once, so you have to make a choice about when to call them, and so sometimes you have to compromise. But maybe it's because they figured out how to call different witnesses to tell different pieces of the story or whatever. But I've been really impressed by the state's overall narrative construction. And also they're keeping the story relatively simple, which is also a challenge in this particular case, because this particular case is perhaps more interwoven with complexity than any other case I can remember of recent memory. Again, it's really hard to keep track, at least in my own mind, what's going on in the story because it's just so much stuff. But
Yeah, let's go ahead and bring that up quickly as call it a motion in limine. Hold
it's
on
a
just
good
moment.
thing.
I'll log on and go on the record.
So yeah, and things are good, so I'm happy. So the court is about to get started, so let's just get the audio set up and working properly. Uh-huh. I don't know if it's set up properly or not. I suppose we'll find out once the court starts talking. Looks right. No, that doesn't look right. Yes, it does look right. Okay, that looks right, so I think it's correct. The camera person seems to have figured out how to correct the backlight problem. I don't really think there is no camera person. There is no camera person. It's just a automated thing. So they lowered the blinds to help prevent the screen from being bled out to facilitate the viewing of the screen. So the blinds are down in the courtroom to prevent the screen from being washed out. Yeah, the court is just getting started for the afternoon. The blinds were open. They look closed to me. It looks closed to me. I mean, I'm looking right at it. You tell me. They're on screen. They look closed to me. You tell me. Well, Oh, those aren't blinds. Oh, wait, maybe they are blinds. I don't know what's going on. The blinds behind the defense are open, but there looks like there's blinds in the courtroom. I'm not quite sure. Yeah, I'm not quite sure what's going on that one. All right, so yeah, I don't know. It's not. There's not a camera person though, so I don't think that's the solution. Okay, so why can you not hear anything? Well, I can do this a different way. I think. Yeah, let me just change it to this. I can just do this directly.
With the court's ruling.
Yeah, there you go.
And
that works.
This is going to be walking a tightrope here, and my instincts tell me that there's a likelihood that could come out, Judge.
All right, thank you, Mr. Pryor. What's the response to the state? And the court will note I previously entered a ruling that the 2007 apparently felony case or conviction involving Alex Cox and Joe Ryan was irrelevant in this case. Hence the concern of the defense if it comes out that there was a felony conviction that may have prevented lawful purchase of firearms. I don't have that information before me, but if it's an appropriate area of cross, it may come in. So how does the state respond?
Your Honor, the state still sees this situation the exact same. The 2007 event is still very attenuated by time. It's the state's understanding that there was a withheld judgment, and as such, Mr. Cox was able to legally purchase firearms. And so I don't know how that would affect anything related to this case. If he was able to legally purchase the firearms, and honestly, even if he wasn't able to, I don't know that that would make a difference when it comes to bringing in a 2007 event. Again, the state's understanding is he was able to legally purchase those firearms. And so we believe that the standing or the ruling from the court before under Rule 401 and 403 should stand. It's too attenuated by time to be relevant to this case.
Judge, in response, I guess my concern is not necessarily openly pursuing that because you already told me I can't. My concern is that if I ask this witness, is there anything that was preventing Alex Cox from purchasing firearms prior to 2019? If this officer testifies, and I guess if someone wants to let him know and say, no, I don't know anything about it, I guess that solves the problem. But at this point, I don't know what the officer is going to say. If he says, I don't know, I guess the inquiry's over, isn't it?
Well, it may be. And so on the issue, first I'll note under the State versus Ochoa case 169 Idaho 903, the court has broad discretion to admit or exclude evidence. And I have to consider under 401 and 403 what's relevant in a balancing test. I've done that previously as it relates to just sua sponte bringing up this 2007 conviction. I would note, however, though, that if there is a proper line of inquiry on cross that goes back to that time frame, then there may well be a relevance if part of the state's allegation was that the time frame of firearm purchases started at a certain time. I don't have any idea what this witness, Detective Considas, may or may not know about Alex Cox's previous criminal history, whether there was a felony conviction, a withheld judgment, when that would have occurred, when he may or may not have been prohibited from purchasing firearms, but it could well be relevant to the issue at hand. What I would rule here is a narrowing instruction that if the matter comes up and you want to inquire, Mr. Pryor, you can just ask in general terms if you're aware if Alex Cox did have a felony conviction that prevented him from purchasing firearms, but not go into the details about who the victim was or what the conviction would have been. And if he knows a history of whether the felony resulted in a withheld judgment or whether Alex Cox had any sort of lawful prohibition against purchasing firearms. So as far as keeping it general, if it goes there and he knows, I would permit that. Otherwise, if he doesn't know, then again, the topic I've already ruled would not be relevant for trial. So that's how we'll proceed, with just a limiting instruction that you could inquire, but not in detail about who the victim may have been.
And Judge, I just want to make it clear that I'm permitted then to ask this officer whether or not he's familiar, if at any time there was anything preventing Alex Cox prior to 2019 from purchasing firearms, or was there any felony conviction? Is that where the court will allow me to go?
I would permit that. I think that may
Thank
be
you,
a
Judge.
relevant line of inquiry. So that'll
Yeah.
be the court's ruling on the matter. I will deem that to be a motion in limine ruling. With that concluded, then we can have the detective return to the courtroom and the jurors brought in, please.
Let's do.
No, it's fine.
It failed.
All right.
The jury is present.
All right,
I'm
thank you.
trying to make
Please be
payment
seated.
using my business credit card, and for some reason it's failing, and I can't figure out why, and I'm getting frustrated.
We have concluded the lunch recess. Detective Considas is on the stand, continuing in direct examination. I'll remind the detective he's still under oath. Also, for those in attendance today, the courtroom conduct order remains in effect through the afternoon. We'll continue at this time then with additional direct examination. Mr. Wood.
Your Honor, the state has no further questions for this witness at this time.
Okay, then Mr. Pryor, cross-examination.
Payment failed. What is the problem? Payment failed is not helpful. I need like more specific information. What is the nature of the problem? Could you help me? Could you help give me more information? I'm having a day filled with frustration, it seems. Today is apparently let's frustrate uncivil day.
Your Honor, I'm going to ask if that was on the record, and if it is, I'm going to move to strike it.
Let's
didn't
frustrate
hear it,
uncivil
so I
day.
apologize.
That's what's going on.
Judge, I had
It's on the
comment.
sidebar.
Let me just try deleting like every payment that this person has on profile and just like set it up again. Maybe that will work.
If you could just bear with me, Detective, I apologize for.
And Mr. Pryor,
All
make
right,
sure your
let's try
mic's turned
again.
on.
I think that verifies it. So Detective, I'm going to bounce around a little bit. Do you mind?
No.
Okay. By all indications of what you've testified today, it appears that Alex Cox and Lori Vallow had a very close relationship. Is that fair?
Yes.
Okay. they shared multiple accounts, and by your count, how many accounts did they share together?
I believe it was just that one Barclays credit card account.
Oh, I was under the impression there were a couple of bank accounts that they shared together in addition to credit cards. Is that right? Do you need to refresh your recollection?
Yes, please.
By whatever it takes. Do you
Okay.
have your book up there? Mr. Wood has it. No, I can't.
We'll have the bailiff deliver those exhibits to the witness, please.
Take whatever time you need, officer, as well, okay?
Thank you.
Confirm purchase? Come on. Okay, I can't figure out what's going here.
I believe I can recollect that there's only the one account, the Barclays credit card, that she was on Alex's account.
And was Alex on any of her accounts?
I don't believe so.
Okay, I may have misunderstood your testimony then. Now, you went over a timeline, and I think it was 303 was the timeline. Do you recall that?
Yes.
If I could.
Yeah, and, please indicate what you're publishing there, Mr. Pryor.
I think it's 303, Judge. The exhibit, Mr. Wood.
All right, exhibit 303, that's being published.
Try to get that where we are here. Okay. So I'm looking at
Is it a problem with
303,
my bank?
and it talks about Chad Daybell and Lori Vallow met in
I think
2018.
they tell you if there's a problem, like my bank
Correct?
has some sort of
Correct.
hold on it.
Okay, and then there was a flight to Mesa, Arizona on 1/6 of 2019. You see
Correct.
that? Was that a business trip for Mr. Daybell? Do you know?
I don't.
Do you know whether or not he was appearing at a podcast on that
Scam
day?
alert?
I have no information of that.
Okay, and then we go to 3/19/2019. Are you aware that Mr. Daybell may have been on a business trip that day?
I was unaware.
Okay. Were you aware of what Mr. Daybell's occupation is?
He owned a Spring Creek Books.
No,
Okay.
that doesn't
Book
seem
company?
to be it.
Books, right?
Books, sells books,
Right.
did some podcasting, and he also spoke at some events.
This might be
Right.
the
So
first
he would
payment I'm
travel
making
on
with this
occasion, and you
address.
saw a history of that as well. That he
Yeah.
would travel and go to various locations for various reasons, correct?
Yes.
Okay. So we don't know what the purpose of that is. What we know is that he met Lori Vallow in October of 2018, and that he traveled for a couple of trips. Okay, and then on the same timeline, you put Charles Vallow's death back on July 11th of 2019. Mr. Daybell traveling twice, what does that have to do with Charles Vallow's death?
Doesn't have anything to do with Charles Vallow's death.
Then why'd you put it on this timeline?
Just to show it from January of 2019 across the entire year.
Or was it just to get a reaction from the jury so that they would say, oh my goodness, he's traveling and he must be going to see someone, even though you don't even know what he was going for, right?
Objection argumentative.
Sustained. Counsel, apparently we need a brief sidebar quickly, sorry.
This is for my business account. So I updated my business account, not to where I live, but to where my to my registered agent. So I don't know what the fuck's going on. All right, let me try adding it again, I guess. Payment failed. I don't want to use a different card. I want to use my business card because it's a business expense. And I don't want to have to like keep track of it separately. That's why I have a business card in the first place, to make it easier for tax purposes. So I have all my business stuff on a business card. That's the idea. So I don't want to use a different card, and it won't let me use my business card, and I can't figure out why, and I'm getting a little bit pissed. Call them. I can't. There's no phone number for me to call. There's no phone call for me. There's no phone. Yeah, there's nothing for me to do here. There's no phone number listed. Why would you think there's a phone number? Can I call the bank? I guess I could call the bank. Let's see what's going on. Hold on. I'll go off stream so I can call the bank. I'll be back.
Rise, if the court begin in session.
All right, thank you. Please be seated. Okay, we are back on the record on CR 22211623. We took a sidebar. There had been a concern about potentially some unauthorized recording of the proceedings. The court would remind all of those in attendance that according to the court's courtroom conduct order, no unauthorized recording of any type, audio or video, is permitted. And if you have a device doing that, you may not only be required to leave the courtroom, you could be held in contempt by the court. So I will remind those in attendance here of that. We didn't confirm anything. That was the reason for the delay, is to address that concern. I do want the jurors to know it was only a concern about a potential recording of audio, and also that the delay was not in any way caused by anything done by counsel, the state or the defense here. It was simply us trying to maintain the court's order of the courtroom without unauthorized recording taking place, which again, we have not even confirmed occurred. That was the purpose of the delay. So I apologize for interrupting you, Mr. Pryor. If you'd like to get on with your cross-examination at this point, then you may continue.
And could I inquire the last question, just so I know where I was?
There was a question actually with a sustained objection that was argumentative. And so I think if you just want to start over on a new
Okay.
question, you were talking about the 2019 timeline.
So if I understand on the timeline of 2019, the purpose is to show contact between Chad Daybell and Lori Vallow?
Well, it shows that Lori was paying for Chad's flights, so there is some contact there.
Okay. Okay. And we don't know what those flights are for, right?
No,
And how many flights are you claiming he paid or that she paid for him
on this page here or in total?
total?
I'd have to review the whole document to see it.
Go ahead. 'Cause that needs, if you need to do that, refresh your recollection, go ahead.
Can I use my exhibit here? 'Cause it's-
Absolutely,
okay.
please.
Appears to be just 2 flights.
And those would be on the 2019 of January and March of 2019, correct?
Yes,
That really has nothing to do with the death of Charles Vallow, does it?
no,
Okay. What it has to do is apparently one of them's buying flights for the other, right?
yes,
And it's not really suggesting anything else other than that, right?
no.
Okay. Okay. Did you happen to know the facts surrounding Charles Vallow's death?
I don't know all the facts, but I'm aware of some of them.
And you're also aware that Chad Daybell hasn't been criminally implicated in being charged with any of the matters relating to Charles Vallow, correct?
That's my understanding.
Okay. So when we're looking at when they met and at the top where you said Charles Vallow's death, all due respect, officers, this seems to be implying that in some way buying 2 tickets, Lori Vallow buying Chad Daybell 2 tickets somehow implicates him in that. That's not what you're suggesting, is it?
No,
Okay. Now you mentioned, and Judge, could I have Exhibit 34? And I'm going to move for admission of G through, I think it's J. the ones that have not been admitted as of yet. I think A through F have been admitted. The remainder on that drive, I'm asking to be admitted by stipulation of the parties, Judge.
All right, are you gonna, it's on a thumb drive, Mr. Pryor.
Yeah, if I could have the thumb drive, Judge, I can take the exhibit, plug it in, and then discuss what I need to discuss with the officer.
Okay, you can go ahead and plug that in. Before we publish anything, we need to go through whether or not these additional exhibits are admitted or not.
They've been stipulated, Judge, as admission,
Okay,
the state and myself.
Okay, yeah,
So G through J,
that
the
problem
state
has
does
been
not
resolved.
object
So
to
it
them being
turned out
admitted, is that
that the
correct?
problem was my bank, who apparently
believe that's
decided
correct,
the
without
$2
seeing it on
super
the screen.
chat
I'm not exactly sure what.
I did
This exhibit
yesterday
is,
was
though.
suspicious.
If you'll just speak up, if you see something. you
I'm
believe
not
is
sure why they
admitted by
decided the
stipulation,
$2 super chat I did
I'll
yesterday
rule
was
at this
suspicious,
point exhibits
but apparently that was the
34
problem.
Remaining documents G through J are admitted.
I have now
and
made the purchase I was trying to make
Mr.
in the
Pryor,
first
perhaps you
place.
could make a proffer of what each one is.
So that
before you
problem
publish
has,
it, just so
for the
the
moment,
state's
been
aware.
resolved.
And Judge, just
And my
so
desire to kill
all the parties understand,
is
those
being
are just,
reduced.
emails by Alex Cox, or excuse me, emails. Those are searches by Alex Cox in relation to firearms during a pertinent period. And
And
that's what
yes,
those
I
were.
put the
And,
super chats on my
Judge,
business
they are
card
part and
because
parcel
I
of
put
the-
them under my
the mass,
username. Right? They're under my channel
stipulation
name,
regarding,
which makes them an
all of the contents
advertisement,
of, I think it's Homer J.
which means it's a
Maximus
tax
and,
write-off.
30 exhibit number 34,
So,
which by agreement of the prosecution
yeah.
state, all of the contents of the Homer J. Maximus account are stipulated to be admissible.
Okay,
May I proceed, Your Honor?
you may.
So, officer, we're going to switch again.
So 20% of my super chat price
You
is paid for
testified about
by my fellow taxpayers. Thank you very much for
the
subsidizing me.
records as they relate to Alex Cox and the period of time when there were some interest in firearms, correct? Correct. And what I heard your testimony, at least the way I took it, is that you're suggesting that that's the only time that Alex
305
Cox ever looked at
pound
firearms.
hack squat
Objection
today, though.
states the testimony.
So I got that going for me.
I'll rephrase.
305-pound
Are
hack
you
squat
suggesting
for
that that was the
reps.
only time that Alex Cox ever looked
In
at
addition to my
firearms?
750-pound
Okay, so the
leg
purpose
press
of
on Monday.
Identifying firearms during that specific period was just to show that
So I got
on
that
his,
going for me.
purchases, he seemed to buy a lot of firearms at that time.
In that short amount of time, correct.
Okay. Were you aware that he had looked at firearms on other occasions?
Kill.
Are you
Kill.
aware of anything that would
Kill.
prevent Alex Cox from purchasing firearms?
No.
Were you aware in anything in previous life as it related to Alex Cox, a felony conviction that would prevent Alex Cox from purchasing firearms?
I understand that there was an arrest, but it did not hamper or hinder his ability to obtain firearms.
Okay, and
I
the
also
nature of that
maxed out the
arrest
seated
was what?
back extension
I believe it
machine.
was a
Your
physical-
Honor, I'm going to.
So I'm
object
not
to
sure
this
what to do
point. I
about
think
that.
Pursuant to the
I
court's
maxed out
earlier
the seated
order,
back extension machine. So
I don't
I
think this can go any further.
don't know what I'm
Also,
supposed to do
uh,
now.
It's calling for something that's I've considered
Use a back
irrelevant. If you
extension
wanna re-ask the
bench
question, Mr.
instead?
Pryor, as it just relates to the.
But I don't want to hyperextend my
charge or
back because
conviction.
that's a real problem. That's why I was using the
So
machine
there
in the
was a
first place
felony
because it's
conviction,
safer.
there was a felony conviction of Alex Cox in what year?
How can I
sir?
magically make the weight go up?
Unknown year. I don't know what year it was.
In his previous
Man.
history?
Yes.
Okay. And as a result of that, you're not aware of whether or not that was a restriction on his ability to purchase firearms. Is that right?
My understanding is that the arrest or the plea agreement or something to that effect didn't violate or hinder his ability to obtain firearms. That's my understanding of it.
Okay. So in other words, the disposition and after the disposition, when he was sentenced and it was resolved, your position is that it didn't inhibit him in any way to pursue
I was doing
an interest in any kind of firearms.
200
My
pound
understanding.
And where did you gain that knowledge
decline
from?
chest press
Don't recall.
using
It
the
was,
Hammersmith machine. 100 pounds
I
on
don't
each
wanna-
side because they're independent on the
I don't
Hammersmith.
recall specifically where I.
So I was
heard that.
doing
Okay.
I was doing 200-pound decline chest press today.
Judge, I'm just waiting for this to queue up. There we are. So again, as part of your, and we may not have to go into this, but as part of your determination, all you were really looking at during that period was an interest in a purchase of firearms in that specific
Is
period.
that what I
correct?
logged?
If we were looking for that specifically, but it did, having reviewed the
130
documents for
pound
the year
lat pull down.
2019, in that short amount
And
of
then,
time,
yeah,
there
100
was
pound
some
on each
purchases
side.
being made.
Okay. But you
And
didn't
200
look back in any other
250
periods,
pound
is that right?
No. we were
250 pound
Sorry.
back
Sorry.
extensions
We were just looking in a specific
Times
time
10.
frame for
Okay.
times 3.
Okay. And you mentioned a shooting of Tammy Daybell. Is that right?
Where's that times 3 times
And
10?
were you aware that the
Yeah, it's
evidence
probably times 3
as far as
times
Tammy
10
Daybell is that she was alleging
is
that
the
it was a
more
paintball
classic way of
gun?
expressing that.
I'm
3
aware of
sets of
that.
10.
Okay, so how is it that talking to this jury about all these
I don't even
purchases
know
of
which way it
firearms has
doesn't
anything
matter.
to do with a
I don't
paintball
think it
incident?
Yeah,
Objection misstates the testimony.
Overruled.
You can answer it, sir.
Repeat the question, please.
How is all of the purchase of these firearms during that period have anything to do with Tammy Daybell having a
It's
paintball
not
gun
math,
shot at her?
right? Because that's the proper way of expressing it. That's the proper way of expressing it, because
As far as the
you're
timeline was
you're
concerned,
measure you're
it doesn't,
doing
but
sets times reps times
it was,
weight.
on the
So
timeline
that's
of
the proper way
events
of expressing
for
it,
the
as far
year.
as I can tell.
Oh, okay. And you
So
chose
3
which
times
events are on
10
the
times
timeline, right?
250
They
would be
were-
the correct way of expressing it.
They were
3 sets of
major
10
events,
at
if you will,
250.
for
So
key dates.
yeah,
Okay. And some of those major events were a paintball gun being shot at you, right?
Yes.
Okay. I at any time during the review of all of the bank records, did
that
Chad
equation is math.
and Lori ever have a joint account at
Well, it's
any
pretty
time?
easy math. Times 10 is
I don't believe they
2,500.
did.
Okay.
Times 3 is
Even after they're
7,500.
married.
So it's pretty easy
Right.
enough.
They never commingled their money, did they?
Not that we were, no.
Okay. Yet Alex and Lori did, right?
Yes, on that one account, yes.
Okay. Now you talked about Tylee's bank account and how you
Yeah,
believe
total weight
used
lifted
after
today,
what you feel is the date that Tylee,
27,265
had the
pounds.
last known proof of life, right? And you-
So
and
Which
I'll,
account was that?
well, it
not
was the
quite
account where you
16
talked
tons,
about
but
the
close.
Costa Vida, the 2 trips to Costa Vida.
That would be her BBVA
Uh,
account, yes.
Okay. Did you
let's
look
see, that would
into-
be
Did you look into who was
14
who were the
tons. What do
participants
you
in that
get?
Costa Vida?
another day or
Yeah,
the
we
deeper a
attempted
debt.
to. I went down in person and met with the manager.
Sold my soul to the gym.
We obtained the receipts for them, and we were asking if they had any kind of video or anything that would show whether it was a take-in or a take-out or a dine-in.
Right.
And there was no video. Too much time had passed for any video feed to show exactly who used the card. But we know when that Tylee's phone was in the immediate area of the cell tower footage, or in the range of the cell towers next to the Costa Vida that would fall into that area. And based on when Chad and Lori were detained in Hawaii in possession of Tylee's phone, that led us to believe that it was not Tylee that made that purchase.
Okay.
Of Costa Vida.
And
On the hack
appreciate
squat,
that, but I'm
the
grateful
top safety
for you to
mark,
point out that you took the liberty
because
of,
there's there on the
looking at
machines.
the,
there's a
the GPS
like on the leg press
information for
machine.
Tylee's
There's a
phone. I
safety.
appreciate that. Did you?
And I always put it
Did
on
you
the.
happen
I
to
always
look
put it
at
on the most
GPS
aggressive setting.
information
because
As it
for me,
relates to
like
Alex Cox on both of those days and
my
whether he was
knees
at the Costa
come down.
Vida?
Like I guess because of my height.
Would it
It's a height thing because of my height,
Cox at the
right? Because I'm
Costa
tall.
Vida on both of those cases, both of
So
those instances with
I
Lori
need the
Vallow
safety at the
using
most aggressive setting
that particular
because my
account? Would
legs
that
are so long.
surprise you?
Objection, facts not in evidence.
But yeah, so basically
asked
on the
what
hack
surprised
squad,
him.
I had the
Well,
safety at the
the
most
way it's
aggressive
asked,
setting,
I'll
and the
sustain
safety was just
objection.
slightly
So
lower.
you didn't look at
then I
Alex
would go
Cox's,
anyway.
GPS
So I just
records to
hit
determine
the
whether
safety
Alex
every
Cox
time.
was
That was my
one of
that
the
was
people
that
at
was my
Costa Vida
indication that
during
I was at the right
luncheon
depth.
and the use of
It's like,
Tylee's
how do I know
car,
I'm at the
right?
right depth?
Just
The
know
the
that Tylee's
clang
phone
of
was
the
down in that area, and
the
that's all
machine
GPS
hitting the
records.
safety.
Okay, but you didn't
Was
go
the-
any
was
further.
the-
You had access
was
to the
the-
GPS
was how I
records of
knew
those
that I was
folks,
at the
right?
right depth.
I did not. I would go and ask, and and then information would come back just to follow up on information. That's all. I didn't
Well,
review.
so as part of a law enforcement cooperative with all of these folks, you weren't sharing GPS information with the other agencies regarding Alex Cox's GPS information?
Not a forensic computer analysis.
Okay.
That's not my position at the police department. So
Well,
I didn't have physical custody of
What's
that.
my height?
Well,
6
and I
foot.
guess that's why I'm wondering how important this information is that the card was used, because you had the ability to check
But
Alex
the
Cox's
machines are
phone
built for
to determine
men
he
and
was
women
there,
alike.
right?
So
The
because you know
ability-
it's just a machine.
You
It
had
doesn't
the
know if you're a
ability
male
to
or
inquire
female.
from
So
one of the many agencies working
settings
on this
for
thing is
people
to
who are,
determine
you
who
know,
exactly was there,
like 5'2" or something.
because you had everybody's phones, right?
Tylee's card was used and Tylee's phone was in the air in that immediate area. That's all the information I had.
So you're not looking to suggest by telling this jury that the card was used illegally, that it was people who were engaged in, you're not suggesting Mr. Daybell was there, are you?
That's unknown. I don't know.
Well, and that's what thank you for saying that, because I'm trying to figure out what was the purpose of you telling this jury that the card was used unlawfully. Was it to,
I want to go lift more
was it to
weight
shed
now.
light on somebody, or to just
Just talking about it makes
create
me
a
want to go
hunch that
lift
maybe
something
Mr.
heavy.
Daybell was there when he wasn't?
Objection, argumentative.
Sustained.
The fact is, you didn't go the extra step to find the unknown as to who was using the card, did you?
I feel like
I went
doing
the
some
extra
sort
step
of like
and went
trap
down
bar deadlift right
to
now.
See if there was video of somebody using the card and just knowing
I'm
the
a
record of
masochist.
Tylee's phone
Yeah.
being used. There was no other record of Tylee being around. So that's followed up on.
And I think maybe we're not communicating very clearly. So maybe I need to make it a little clearer. I understand you're saying Tylee wasn't there to use that, but you didn't look into who was using it, did you?
Objection misstates the testimony. He testified that he did look into that.
Sustained.
You can lift you. You weigh
You didn't
160
use any
pounds.
additional
Easy.
GPS information
Easy.
to pin down exactly who was there
I
using
can
the
press
phone, did
you.
you?
Although live weight's a little bit
Okay.
harder than dead weight, but I should be able to manage. Also, it depends on how the weight is distributed, obviously, because with a barbell, it's evenly distributed weight. But yeah, 160 pounds, I probably can press you for reps. So I got that going for me.
Now, there's no information to suggest that Chad Daybell took any of the funds from the Social Security of Tylee or JJ, right?
Correct.
Okay. So those allegations have to do with Lori Vallow.
Yes.
So in regards to Chad Daybell, the issues of all that Social Security and then the money that was taken is just a reflection on Lori Vallow. It's not a reflection on Chad Daybell, is it?
Correct.
Okay. Judge, I think that's all I have. Thank you.
All right, that will conclude the cross. Mr. Wood, if you'd like to redirect, you may.
Just very briefly. Detective, just for clarity, was one of your assignments to review the finances of some of the individuals in this case?
Yes.
Were you responsible for GPS data?
No.
Detective, you were asked about on your timeline the significance of Lori Vallow booking flights for Chad Daybell.
Yes.
Why was that significant to your investigation?
In the totality of the travel timeline, it shows when they meet and then Lori begins buying Chad's flights, paying for Chad's flights, and then Lori traveling to Idaho quite a few times during that window.
So defense counsel asked you about whether or not Mr. Daybell was traveling for business purposes when Lori booked him those flights. Correct?
Yes.
In all your review of the finances, are you aware of Lori Vallow and Chad Daybell being in a business together?
No,
But were they in a relationship together?
I believe so, yes.
And counsel asked you about the social security funds that Lori Vallow received.
Yes.
Was she married to Chad Daybell when she received some of those funds?
Yes.
No further questions, Your Honor.
All right, thank you. And I don't believe that opens up any grounds for cross, so that will conclude the testimony then of Detective Considas. Is this witness going to be recalled, counsel?
Your Honor, he will be.
All right,
And he's under subpoena from my office as well, Judge.
all right. So Detective Considas, then this exclusionary rule still prohibits you from viewing any of the testimony.
You know, if I were a defense
or
lawyer, I'd be
discussing
half
any
tempted to
your
subpoena
testimony
all
with
the
others
state's
that
witnesses
testify in the
just in
trial
case.
Between now and the time you're recalled. I mentioned that.
I don't know if
because
that's
this
really a
case is
viable
being live
option, but
streamed, so
I
please
can't
don't
see any
access
reason
or
why
watch the
not. I
case, and I'll be
mean,
questioning you as to
just in
whether or not
case, like,
you followed this instruction
why
before you
not
return
subpoena all their
for testimony
witnesses?
later whenever that occurs. All right, thank you.
You know, I don't know if any defense lawyers do that. I'd be interested to hear if there's some sort of downside to it. But, you know, just make the state keep guessing as well. I don't know. Are there any criminal defense attorneys out there who might be watching? I'd be interested to see if there's a downside. Has he reserved the right to recall all witnesses so far?
All right, thank you. Mr.
Yeah,
Bailiff,
but
for
you know, just as an
clearing
extra
off the witness
CYA.
stand there. Is the state ready to call another witness?
Yeah.
Yes,
That's what
Your
we
Honor.
do. It's
Who will
30-year
that be?
litigator.
State
Yeah, that's
would
what I'm
call
saying.
Michael Douglas.
Yeah, just subpoena all their witnesses too. Why not?
You happen to know what his title is?
A forensic accountant.
Okay.
Extra work? It's not that much extra work. Can you just totally subpoena people? Well, they need to be relevant to your case, but if the other side is subpoenaing them, the other side is arguing they're relevant. See, so I don't need to prove they're relevant because you've argued they're relevant. You're the one subpoenaing.
And Your Honor, before I inquire, I
So it's
do
like,
have
well, what's the relevance of
courtesy
this witness?
copies
If
for
you
the court.
if you said to me, well, what's the relevance of this
exhibits.
witness? I'd say, well, you tell
And
me.
this goes to
You tell me what the relevance of this witness is.
Okay, I'll have the bailiff submit those.
And if you can't answer the question, then be like, okay, well, then in that case, I move to quash their subpoena because it's not relevant. It's like, so it's like, yeah. You know, and it's a form. I know it's a form. That's what I'm saying. It's just a form. Why not?
All right, the witness has now been sworn. Let me just inquire before you begin testifying, based on the court's exclusionary rule. Have you watched any of this testimony that's occurred in the trial thus far?
No, Your Honor.
Okay, have you talked to anyone else about their testimony that they've provided in the case?
No, sir.
All right.
More work for the
With
process
that
server.
affirmation then, Mr. Wood, if
That's
you'd like
fair.
to inquire, you may.
That's fair. You do have to pay the
Thank
process
you. And
server.
before I
That's fair.
do, can I just verify with the court that State's Exhibit 77 has been admitted?
Yes. Yes, it has.
Okay, thank you. Mr. Douglas, can you state your name and spell your last name for the record?
Michael Douglas, Douglass.
What is your occupation
I'm a forensic accountant,
and who do you work for?
the FBI or the Federal Bureau of Investigations.
How long have you worked for the FBI?
An
Nearly
ethical
7 years.
question?
I'm close.
Eh, And what
I don't
work
think
did
it's
you
an
do
ethical
before that?
question. I mean,
I
I
was
sort of
a
understand your point, but the other
tax
side
and
is subpoenaing
fraud
them.
auditor for the state tax
So,
commission for 4 years.
I don't think there's an ethical issue. It preserves options,
Is
and that's
there
always
a-
ethical
a
for an
title?
attorney, right? I'm just
Yeah,
preserving
or
options.
Forensic accountant that we should call you.
It grants
or
me flexibility.
does Mr.
Flexibility is
Mr.
always
Douglas-
good, right?
okay.
Because now they're my
Mr.
witness.
Douglas is fine.
Okay.
And so the state just can't dismiss
And
them willy-nilly.
Tell me what a
I
forensic
don't know.
accountant
Yeah, I don't
does.
see an ethics issue.
In
Seems okay to me.
we review electronic and financial data, create a financial analysis, provide this information to the investigative team, discuss this with the prosecutors, hold interviews with subjects and witnesses, and testify to our findings.
Right. And when you do a forensic accounting, do you just look at bank accounts, financial records? Do you take other, well, I'll just ask it like that. Do you only look at bank accounts and financial records?
No.
What else do you do?
Uh, Individual search history usually provides additional data where they might be banking at. So search history is one, apps that they have on their phone would be another. So in some electronic data, as well as the financials, provide us additional information where to search records.
And in terms of your investigation overall, do you look at an investigation as a whole when you're doing a forensic accounting to see how the finances might affect other events?
We do, yes.
How did you become involved in the case regarding Mr. Daybell?
My office had been involved with the investigation for a few months before I was inquired to be upon the investigation or in the investigation. I was told that there was a voluminous amount of financial records and requests that had gone out and sought out to review that information.
And so tell us about some of the work you did. How did you get started? What did you do first?
A lot of the work had been done for me before I got on. The PD had sent out multiple search warrants and subpoenas for the financial records, some travel information. And then when I was brought on around March of 2020, a lot of the records were starting to come in and started reviewing.
Karen Reed case?
As it
I've heard
trickled in
things.
and built
I've heard things.
a large spreadsheet.
I think
of
Nate the lawyer
whose
was saying to
accounts,
me that I should cover
whose
both.
transactions these
But I'm not
were,
sure how
what
that would work
bank they were
practically.
affiliated with.
With like trying to cover
And it
two
got to
trials
the
that are
tune of
ongoing
nearly 80 bank
simultaneously,
accounts and
that'd be
credit
really
cards.
weird trying to float
Alright.
between both cases
And
at the same
you
time.
said the PD. Can you?
I'm not
tell
sure
the
that
jury
that's
what
really
the PD
viable.
is?
The Rexburg Police Department, sorry.
And so you worked for the FBI, but you worked with the Rexburg Police Department at some level in this case.
I did.
All right. And I'm sorry, you said approximately 80 accounts were looked at.
Yes.
Your Honor, I'm going to ask that can I have the witness be handed State's Exhibit 111? Detective, is part of, well, I'll wait till you get that.
Thank you.
Are you familiar with State's Exhibit 111?
I am.
What does it purport to be?
This is a timeline that I created regarding Tylee's bank account records, including her JP Morgan Chase account and her BBVA, or as I also call it, her Compass account, and the transactions that took place monthly in each.
Is the full name of BBVA Compass?
It's a Southern bank, but yeah, BBVA Compass is the full.
And so as part of your investigation, did you do a review of Tylee's finances?
I did.
And what did that entail?
So with Tylee's, originally we had a much smaller, we had to send a supplemental request to get the full data. Tylee was a minor, so she had a bank account with her mother, Lori. And this included what will be noted as in blue as the JP Morgan Chase account, 3918 deposits. Tylee was receiving Social Security, as I'll discuss later, from the death of her father, Joe Ryan. And these deposits, that's what the blue indicates. The orange is indicative of the transactions that were taking place in this account. And then Lori and Tylee opened Tylee's BBVA Compass account ending 5794. The deposits that go into this, I'll explain later. These come from an account that Lori had with BBVA. And then the withdrawals will be noted in red of the transactions that took place starting in August and in March of 2020.
And so on State's Exhibit 111, is this a document you created?
Yes,
And is it, is the purpose of this document to demonstrate the level of transactions in these accounts over a given period of time?
it is.
And did you prepare this
I did.
based on those bank accounts you just discussed?
Correct.
And did you do that in preparation for your testimony today?
I did.
Is it your belief that this would aid the jury in understanding the level of transactions over time in Tylee Ryan's bank accounts?
Yes,
And is this a true and accurate copy of what you created?
this is. Yes.
Your Honor, I'd ask that State's Exhibit 111 be admitted into evidence for demonstrative purposes.
For demonstrative purposes, there's no objection, Your Honor.
Very well. Exhibit 111 is admitted.
And may I publish?
Yes, you may.
Thank you.
And Mr. Douglas, you kind of described it earlier, but can you walk us through how you created this document?
So the original data I took from the bank statements that came in from the bank, put that into an Excel spreadsheet, and then basically separated that data out monthly to show deposits and withdrawals that took place within the accounts, and over time, the change in the accounts specifically to August and September.
All right, and this graph represents the number of transactions, correct?
Correct.
Not a dollar amount.
No.
So what did you learn in your investigation as you put this together?
So first, I would like to say Tylee was very responsible with her money. I never saw a negative balance in her account, but this includes the deposits that were coming into her account, specifically from the money she was receiving from Social Security. And then as noted in orange, these were the monthly transactions, basically what I'll refer to as brick and mortar, as well as her electronic. She had electronic payments for her Apple account, her T-Mobile, as well as her Jeep that I'll discuss later.
And so on that graph, on August of 2019 to September of 2019, it appears there's a change in the number of transactions. Is that fair to say?
Yes.
And why was that important to you in your investigation?
So Tylee had her JP Morgan account, as did her mother, Lori, had multiple JP Morgan accounts. Tylee was making her payments on time and had no reason for the change in her financial status. As I'll describe later, Tylee's Social Security payments get transferred from her JP Morgan account to her mother's BBVA account, her mother being Lori, to which it stays that way, like it never transfers back. This information in August shows that Tylee opens a BBVA Compass account, but the money that goes into it is transferred to her from Lori. Again, she doesn't ever get the money directly. I will also note that we'll discuss later that she had a job working for her uncle, Jeff Shiflett, Dr. Shiflett at J&S Investments too.
Right, and does that account for some of the deposits?
Yes, earlier in the beginning of 2019.
And again, just to clarify, those numbers just represent transaction numbers, not dollar amounts.
Correct.
Okay. Your Honor, I'd ask that the witness be handed what's been marked as State's Exhibit 112.
Friday we could have watched Reed. Maybe. I might take the day off. I could use it to write. I'd like to sort of finalize what I was doing. I was kind of hoping to do it today, to be honest, but I'm
Judge,
so
could we approach
tired.
briefly?
Yes.
Yeah. I'm hoping Daybell will really catch on. We got 232. I'd like to really see those numbers increase. Preferably fivefold at least would be nice. It is a bit quiet at the moment. I didn't see the short that Peter Tragos did. I think I remember seeing mention of it by somebody, but I don't really know what the details were. I want to say I saw like the title by Andrew Branca, maybe, or something like that. I saw something. You post this on LNC. I appreciate it. It would be helpful if you're a little bit more subtle about it, though, because they might ban you or something. But I appreciate you spreading the word to other people. Other people might wish to watch this with some commentary or stuff. RA did it first, and everyone else took his cut and reacted. Fair. Is Daybell anything interesting happened today? Daybell may in fact be guilty. The defendant was trying to get a proffer and the judge walked out. Well, without knowing more, it's a little bit hard to judge on that, you know? But did the judge say, like, no? And it's like, well, if you're going to talk, I'm just going to leave. Because, no. I mean, and did the judge have cause to say no? I mean, I don't know, right? So it's like, without knowing more, it's hard to pick a side in this thing, right? He limited cross to 4 minutes of a key witness. That seems a bit suspicious. Yeah, it seems like, why? 4 minutes, you know, that seems awfully tight. The judge was allowed 5 minutes for questioning. Yeah, like, why though? Right. Is the only, I remember reading a case once, and I forget where, but I remember reading a case, or I didn't read the case, or I read the appeal, right? I remember reading a case where a trial judge used the chess clock in a criminal case, and the defense ran out of time. And so the judge saying, well, you know, these were established in advance, right? So it's like, these are the time frames. You ran out of time. So the judge said, well, I'm not going to permit you to cross-examine anymore for the defense, right? Or offer like a closing argument. And the Court of Appeals said there is a confrontation clause, right? There's the right to confront. And so you can't at least in that one case, in that one situation. I only know of one time it came up. But the Court of Appeals said you can't reduce it to 0. But it doesn't have to be much more than 0, apparently, if I remember reading the case correctly. It's like, okay, you can't deny them the right to cross-examine at all because they have a confrontation right. But you do have a right to manage your court. So you can reduce it down to, like, not much. So if the judge was doing that, right, it's like, oh, you've burned all your time, but because of the confrontation clause, I'm going to give you 5 minutes anyway, and that's all you get, then, you know, maybe that's legal. At least one court seemed to suggest as much. But,
was a co-signer on, and they co-signed on this Jeep April 17th of 2019. And Tylee started making those payments June 3rd of 2019.
judge said the trial was taking too long, so suddenly defense had 5 minutes to finish cross.
July 11th of 2019.
Yeah, that's not equitable.
Right. And
Right, unless
Charles
again,
Baldwin
unless
was
the
trying to
defense is
step
the
up.
one like just
Correct.
consuming too much time and just dicking around. But you know, because you want to look for reasons where it's legal, right? You want to look for
And
reasons why the
this is
judge
still the
why
same
why
timeline,
why
correct?
did the
This
judge
is the
do
same
something?
timeline.
And it's like, at least to me, it's like I want to look for
Can you
reasons why it's
Tell
legal.
us about the first couple of boxes.
Is my first impulse.
So
Like, why is it legal?
I was given this information
So-
that through Lori's iCloud account that
And not to
July
finish cross,
18th
that's
of
all she had. Yeah.
2019,
Well, yeah,
Lori
I
had
understand.
texted Chad that she would not be receiving life insurance money regarding the death of Charles Vallow. But
Judge
she
was
would
supposed to be
receiving
3 weeks. State is still in
$4,000 a
case in
month
chief
Social
and 3-week
Security.
mark. Judge will
July
told them the
24th
jury
of
will get the case
19,
next
this
Thursday.
is the
Defense is
last
going to
Social
start their
Security
case.
payment deposited into Tylee's JP
That doesn't
Chase
seem-
account.
That doesn't seem
and
right.
then 3918.
Yeah, that doesn't seem right. That's hard
Okay.
to justify.
Um,
If the judge
it
said
looks
this is
like
going to be
on
3 weeks and the
April
state has
was
consumed it all,
different subject. What
yeah,
happened
no.
there?
So we found out
Right,
that
so you gotta
Lori
make
had
this
a life
equitable
insurance policy
in some
her
sort of
name
sense.
to the tune of $2 million.
Actually, you have to do slightly better than
And,
equitable for the reasons I
There
mentioned.
was a change
because the
made
defense
on this
has
life
constitutional
insurance
rights.
policy,
So you have to do
making
slightly
Colby
better than
Ryan,
equitable
Tylee's
to
older
preserve the
brother,
defendant's rights.
the sole
So
beneficiary
that doesn't
and
sound right.
100% beneficiary.
This is like, okay, the trial's supposed to take 3 weeks, and the state's consumed them all. Therefore, you don't get as much time. It's like
Your
that.
Honor,
That doesn't sound right.
The court had asked us to stop.
Courts do get a lot of power to manage their
Okay,
time,
thank
but
you,
that's
Mr.
not it, Chief.
We will take
yeah,
a
that's what we call
mid-afternoon
abusive
recess at
discretion
this
in the
time.
trade.
We'll continue on
That's
till
abuse. That's what
3:30
abusive
today.
discretion looks like, right?
To
You have
the
the
extent we
power
can
to
keep
manage your
this break
time,
a little
but
shorter
not
if
that much,
possible
man.
To get all the jurors accommodated, perhaps 20 minutes, and we could come back on at 2:30.
You wanna-
I should react to it. Yeah, okay, I'll do a reaction. That's fine. The judge changed his stance over the weekend. I hope so. I hope he changed his stance, to be honest. As he realized, that was bad. Hopefully he allowed the defense to cross-examine then. The trial judge can always reverse their own rulings, and that's always fine. So if the judge figured it out and be like, that was a dumb thing to do. Oh, well, did the judge, allow cross afterwards? Because it went viral? And everyone's like, this is stupid, and so the judge realized he made a boo-boo? Oh, yeah, well, okay, there you go. He just flipped out that day? It happens to the best of us, but of course, in a trial, it's not great. All right, so we can post it, we can respond to this thing. All right, so where can I find, the clip of the judge freaking out? What's the best source for the clip? So I don't have to trudge through, 50 minutes of someone else's video to find the clip. What's the best source to find the clip so I can do a reaction to it? All right, let's check Recovery Addict then. Let's see. There's a 38-minute version. Should I respond to a 38-minute version of the judge walking out of court? It probably would help provide context. Yeah, I'll probably do that. Okay, let's do that. Let's do a 38-minute thing. All right, let me create a new video, and we'll create a new thing, and we'll do that in a new video, because that makes way more sense. And we'll do that. That's fine. Yeah, I want as much context as I can, because more context helps me make a better legal analysis, right? So I want as much context as I need and not more. Stop wasting my time. Stop it. As much context as I need and not more. Oh, Lord. Okay. All right, so let's do this. Let's do this. Let's do this. Let's do this. Great. Okay. Yeah, we'll do a new video. It's fine. All right, so let me set up the redirect to set you over there. Okay. Redirect to myself. Fantastic. Okay, guys, I'm going to go ahead and end the stream. I'm going to pull it up on a new stream, and we'll go from there. Yeah, we'll go from there. All right, so I will see you in 2 or 3 minutes on the other side. Okay? Until then, I've been Uncivil Law. Until later, my friends, I hope all's well. Cheers, my friends, and goodbye.